our economy, and the way justice is experienced by ordinary Ugandans. Today, we have 4 different topics on the program, but they are connected by one common question. Is our law keeping pace with the realities of the people it is meant to serve? Our first discussion is on the legality of suspending the issuance of special certificates of title. Land remains one of the most sensitive areas of law and public policy in Uganda, and decisions affecting land administration have direct consequences for property rights, investment, livelihoods, and confidence in the land registration system. Where an administrative directive or policy decision affects the issuance of titles, we must ask some basic and fundamental questions. What is the legal basis for the decision? Who has the authority to make it? And what happens to people who are already in the process of obtaining their titles? And perhaps more importantly, can a decision suspend or override a process that is provided for by law? These are not merely technical questions for lawyers. They go to the legality, certainty, and the protection of property rights. We therefore look forward to a substantive discussion on the law, the powers of the relevant authorities, and the implications for landowners and the public. Our second topic takes us to a very unique space. From views to value, the rise of content creators and the digital economy in Uganda. The digital economy is no longer something happening somewhere else. It is here and it is growing. Young Ugandans are creating businesses, building audiences, marketing products, producing entertainment, and generating income through platforms that did not exist in their current form a decade ago. We need to move beyond viewing content creation merely as entertainment, because there is an emerging digital economy with real economic value, and our legal and regulatory framework must be capable of recognizing both the opportunities and the rights that come with it. Our third topic is one that goes directly to the experience of people who find themselves in conflict with the criminal justice system, and that is beyond cash bail. Is Uganda's bail system delivering justice? At its core, the question is whether a person who has not been convicted should be deprived of their liberty while waiting for trial, and under what conditions. For many people, mostly those without financial means, the difference between being granted bail and actually being able to secure a release can be enormous. A bail amount that may appear modest on paper can be completely unaffordable for an ordinary Ugandan. So we must ask whether our current approach to bail adequately reflects the constitutional presumption of innocence, the right to liberty, and the principle that pretrial detention should not become punishment before conviction. Finally, we have an update on TechFest 2026, which was officially launched during our 30th Rnblive last week. The launch was an important first step, but the real work begins with ensuring that TechFest becomes a meaningful platform for learning, innovation, and engagement around technology and the legal profession. We shall be receiving updates on how far the organizing team has gone and what they're preparing for us for that 17th and 18th of September. As we begin today's sessions, I want to emphasize that Rnblive is about asking different questions, identifying practical solutions for the well-being of all Ugandans. Whether we're talking about land titles, the digital economy, bail, or legal technology, the underlying objective remains the same: a legal system that is lawful, fair, accessible, and responsive to the realities of the people it serves. I thank our speakers and the Rnblive team for putting together today's program, and I wish you a successful discussion today. Thank you all so much. Those are the remarks from our CEO. Thank you so much, CEO, in your absence, for sharing these remarks with us. Not to waste so much time, as you can see, we have a lot on the program. 4 topics is heavy. I request every speaker, when you're given the chance to speak, kindly do use the minutes that were allocated to you profitably. So we shall be going straight to the first topic on the legality of suspending issuance of certificates of title. This stems from a news that was seen in the news reports on the 14th of August, where the Minister of Land, Housing and Urban Development, Honorable Judith Nabakova, made a directive suspending the issuance of special certificates of title for a period of 3 months. That is from now till December 2026. So since this directive was put out, there's been a bit of arguments or critics coming out to say that the certificate of title is a creature of statute, and there is no way an executive decision made by a minister can override what is provided for under the Registration of Titles Act. So we shall be looking at that today, and we are honored to have a representative from the ministry who will also be hearing from him. We also have a legal professional that will help us understand what this means and what is the legal basis of such a suspension. And also maybe mostly how will it affect those who are maybe already in the process of applying, and what does this mean for them, and what can they do? Are there any remedies available to them? We shall be starting off with Mr. Deo Kalikumutima as our first speaker on this topic. Mr. Kalikumutima is an advocate of the High Court of Uganda with a Bachelor of Laws degree and a postgraduate diploma in legal practice. He also holds a master's in business administration and has several postgraduate qualifications in tax advisory and tax planning. He is the chief executive partner at Kalikumutima and Company Advocates, and he's an associate member of the Chartered Institute of Arbitrators. He also serves as the president, Pharmacy Owners Association. Mr. Kalikumutima, you're most welcome.
Thank you so much, Patience. I would like to thank the Uganda Law Society, the Council, the Executive, and the membership for giving us this opportunity to discuss, to share, to learn. My video will be on and off. I've turned it on for purposes of introduction. Now allow me to turn it off. In the interest of time, I'll be as brief as I can be. The issue we are testing is the legality of the suspension of issuance of certificates of title. I will address the law, I'll address logic, I'll address common sense. And in the interest of time, I'll begin with my answer to the issue, then subsequently submit. In my humble opinion, the minister is a creature of statute. The minister does not have the power, does not have the mandate to suspend, to curtail statutory rights. So, in my opinion, the directive or decision, whichever way you want to address it, was or is ultra vires. The minister did act beyond her powers. But I also want us to address the elephant in the room. Suspension of issuance of special certificates of title, in my opinion, is just a symptom. Not purport to curtail statutory powers. Several decisions. Abeka Solo Chiberu versus Honorable Nataba. There's another one that I'll not mention for personal reasons. Mwesije versus Attorney General National Drug Authority. Then there's the 1970 Uganda Blanket Manufacturers, 1973 Limited versus Attorney General. It's a Supreme Court decision. The law is settled and clear. What the minister did, however well-intentioned, and we do, in my opinion, as Kalikumutima, I appreciate the concerns of the Honorable Minister, and I must confess that I share similar concerns. So, notwithstanding the concerns and intention, her decision was misguided. I'm glad that my learned brother, Mr. Moses Sechito, is on the call. I'm sure he will speak on behalf of the ministry. I did not speak on behalf of the ministry. The ministry has well over 30 advocates. In every zonal office, you have registrars of titles who are advocates. You have the commissioner, land registration, Mr. Baker Mugaino, who's also an advocate. I do not know. Then you have the Honorable Attorney General of the Republic of Uganda, who is the government advisor. You have all these legal minds that are supposed to advise the minister. In my opinion, as Kalipumutima Deo, an advocate and a member of the Uganda Law Society, I do not know whether these legal minds were consulted. That is why I submit that the directive, however well-intentioned, is misguided. That is resolution of the issue. Number two, the law does have a process. The process has been abused. It is very clear. I have done research on fraud in the Republic of Uganda, and the process leading to issuance of special certificates of title has been grossly abused. That is part of the bigger problem. So I will ask at a certain stage, Mr. Secretary, to advise us. What is the statistic? Genuine special titles, special certificates of title versus the fraudulent ones, or the ones that are acquired through a fraudulent process. To the best of my understanding, the genuine or authentic ones, or the process, the clear process, has a higher statistic, but he will advise on that. Thirdly, I'm glad that the Uganda Law Society has interested itself in the matter. Every right has an attendant duty. It is clear registered proprietors have their rights, but it is also clear that as practitioners, as property owners, we also have duties. And that is where I believe there's a problem. Yes, we have the rights, but what is our duty? What role are we playing? And this is for thought. What role are we playing as lawyers, as property owners, to ensure that we fight the bigger problem? In this discussion, fraud is the problem, but it is part of a bigger problem. I'll tell you there's a series of problems, from poor governance or lack of governance, enforcement. I'll give you an example. The Registration of Titles Act is actually a self-contained act. It prescribes, it does have offenses. But how many times do we have fraudsters investigated and prosecuted, subsequently convicted? Yes, we do have cases that have gone through daylight, but we also have a challenge that there has been abuse, and this is not to point fingers. We have so many players in the justice system. We have the police that is playing the investigatory role. We have the office of the DPP. We have the courts of judicature, and of course, us legal practitioners. But there is abuse through the whole value chain. Of course, there's also the discussion of the so-called untouchables. There are renowned fraudsters in this country. A police file is opened up, the fellow is even picked up, then I got a call, powers from above. Is it from God? Which is that above? So we are dealing with a bigger problem. Can the Honorable Minister sort out this problem in 3 months? No. And another question for us as practitioners, how can we help Ministry of Lands to sort out this problem? Yes, complaining is good, but what more can we do to address the issue? And of course, the bigger challenge is the ministry willing to listen? We have seen practitioners treated like doormats. You're not even allowed to express your opinions in some scenarios. However, we also have scenarios where The title's office is open. You will go to the Commission on Land Registration, he will welcome you, Moses Sekito will welcome you, and a few others. Have we exhausted, the point is, have we exhausted the available platforms? I don't think we have. You cannot sort out this problem of fraud in special titles in 3 months. No, you cannot. Now, the other thing is from a business perspective. How is this impacting commerce? How is this impacting trade? Yes, from a finance perspective, we can do a cost-benefit analysis. Someone will argue and say, no, the benefit outweighs the cost. That comes down to what? To argument. Real estate contributes 11 to 15% of the GDP of the Republic of Uganda. If you look at the banking and finance sector, we have so many secured loans. So how is this decision affecting commerce? Because the ministry indeed supports property markets. We have the Uganda Bankers Association now up in arms. Everyone is up in arms. Yet, I sympathize for the Honorable Minister and the ministry. They are trying to solve a problem. But what is the methodology that you're using? And for me, my issue is the methodology. This is reactive. We need to tend towards a proactive approach. Section 69 of the Registration Titles Act has an elaborate procedure. The registered proprietor shall make an application supported by a statutory declaration. In Uganda, we have laws, Statutory Declarations Act, specifically Section 7, I believe. This is a declaration on oath. If you misrepresent, if you tell a lie in that declaration, as a registered proprietor, you are liable. You are liable to a fine. You are liable to imprisonment for 3 months. There is an enforcement problem. There is a very big enforcement problem here. And I would like to, I know Mr. Sechito may be aware about this and everything, but I want us to focus on the critical problem and the solutions there too. Have we exhausted them? No, we have not. I want to thank the Vice President. Today morning, I received a copy of the letter that he wrote to the Honorable Minister, and I'll quickly go to the recommendations of the Uganda Law Society that I agree with. And I will read verbatim. We advise the ministry to pursue the necessary legislative reforms through Parliament by proposing the appropriate amendments to the Registration of Titles Act. Now, I'm sure Mr. Sekito will tell us that they are undergoing a process of law reform, which is good. I want to address a specific scenario on the powers of the Commissioner Land Registration. We have seen recent decisions. Is this something that we are considering in our law reform? I'll request Mr. Sekito to respond to that. Will it resolve the problem in its entirety? It may not, but baby steps will surely lead us somewhere. The courts of judicature have over 162,000 pending cases. Look at land division, we have over 42,000 cases on case backlog, and about 27% cases just pending loading. The Chief Justice of the Republic of Uganda has been advocating for alternative dispute resolution. Will this solve the problem entirely? No, but these are steps. I will re-emphasize the point again. Can we please exhaust existing mechanisms before we take out actions that can be construed as arbitrary? Because like I said at the beginning, this was clearly a misguided decision, misguided in terms of methodology. Fraud is a reality. It is biting every day. We need to address it. Each of us has a duty. I appeal to not just to the executive, I appeal to every member of the Uganda Law Society to be alive to this reality that yes, the rights do exist, but we have duties to join the fight against fraud. I appeal, as I conclude for now, to the Honorable Minister of Lands, and the entire ministry to take proactive decisions, to consult the necessary stakeholders, to appreciate the consequences. Many a times we make decisions without considering all the consequences. The best mathematics that you'll have today is calculating the effect of your decision. Those are my 2 cents. Because of time, I will not go so much into legalese, so many authorities and sections. The law is settled and clear. I believe my time is up. Patience. Or would you like me to continue?
Thank you so much, Councillor Deo. Very firm, very good presentation. I believe if anyone wasn't aware of the news of the directive of the minister, they've been brought up to speed. You've been calling upon Mr. Sechito.
Sorry, just a second, Patience. Sorry, I forgot something important. Sorry, please indulge me. Please, will you accommodate me just for a second?
Yes, please. Yes, please.
Thank you. There is also a very big challenge that has been created by this directive, and I sympathize for the Office of Titles. Section 70 of the Registration of Titles Act is also a provision concerning special certificates of title. The courts of law can order the registrar to issue a special certificate of title. So the question is, Mr. Sechito, what are you going to do in these 3 months if you receive these orders from court and you do not attend to them? If you do not, we are going to file applications for contempt of court. Liability is specific to the person, yet we are saying with section 69, the registered proprietor is the one who should be what? Liable. Now, if you say, no, this is the criteria for now, the guidelines are going to be issued, let us respect court orders, that is discriminatory. The law must be applied uniformly, not selectively. That is not a...
Those are very key issues that are being brought up on board, especially in regards to fraud. Is fraud a sufficient reason, really? Is fraud a sufficient reason, really, to pause the issuance of the certificate of title? And what can we do in case this is the directive that has been taken? As ULS, I think Council has put it clearly, ULS wrote a letter yesterday to the minister, giving the proper what the law says and how this is going to affect many Ugandans, and how this is clearly an issue of checks and balances. A ministerial order cannot override a statutory provision under the law. So we shall be hearing from Mr. Moses Sechito. Allow me to just briefly introduce him. Mr. Sechito is a distinguished attorney and land administration expert with over 13 years of service with Uganda's legal and land management sectors. Currently, he serves as the principal registrar of titles, head of litigation and the Ministry of Lands, Housing and Urban Development, and is also the in charge for trust registration. He possesses exceptional expertise in land law and transactions, dispute resolutions, and regulatory compliance. Mr. Sechito holds a Master of Science in Land Management from Makerere University, complemented by a postgraduate diploma in legal practice, as well as a postgraduate diploma in procurement and supply chain management and a Bachelor of Laws degree. He also has specialized certification as an accredited assessor, mediation, and public management. Throughout his career, he has achieved notable milestones, including litigating over 100 landmark land dispute cases before Uganda's highest courts, and also mediating complex disputes. He has played a pivotal role in drafting key legislation such as the Landlord and Tenant Act, the Real Estate Bill, and he has also been very instrumental in formulating policy guidelines on government land mortgages, trusts, management, and registration. His expertise encompasses intricate land transactions, trust registrations, regulatory frameworks, and dispute resolution mechanisms. Mr. Sechito, thank you so much, first of all, to the ministry for allowing you to be here to speak to us and as well as the general public at large. We are honored to have you. You're most welcome, sir.
Yes, very much, Patience. I am delighted to be part of Uganda Law Society. I want to thank the leadership at Uganda Law Society and Patience particularly. I want to thank my colleagues, the land friends with whom we are in the profession. The topic today is a bit both emotional and legal. Emotional in the aspect that many of us are also landowners, and then legal in the aspect that because we are also lawyers and we owe a duty to the public, and so we should follow the law. Yes, I have carefully listened to my colleague, Mr. Mutima. Thank you very much. I actually appreciated his presentation so well, and he's given both sides of the coin, where it is for and against. I want to thank you for that, Mr. Deo, Mr. Mutima. To begin off, yes, there's a suspension. It's a fact. There's a suspension on the issuance of special certificates of title for now. However, I want to clearly state that it is temporary. Temporary in the sense that it is only for 3 months, but only 3 months at one person. It seems like a year or more than that to another. It is very small. So we at the ministry are at the center of trying to balance interests to ensure that we try to make the best ends for all of us. Special certificates of title, the law is settled as Mr. Karikumtima has clearly stated. I don't need to divulge into that. Everybody who has gone to law school knows what a special certificate of title is, how is it created, under what law, and what requirements are supposed to be provided. All those there are numerous cases and case law under the RTA has ably stated about that. The question is, where is the problem? ADEO has largely tried to take the bull by the horns, and the issue is we are all aware that there is fraud, and fraud exists in very numerous instances. At least, the courts have tried to explain how fraud manifests itself in these land transactions. And the ministry's investigations led by the Honorable Minister for Lands have revealed that issuance of special certificates of title has been one area that has largely led to fraud. How we have seen many of us or many of our clients have lost land under the issuance of special certificates. What are the prevailing circumstances? We have noted that very many people, including ourselves, members of the Uganda Law Society, either as lawyers to our clients or as interested persons, we have lost land. Why? Because a special certificate of title has been issued over your land or over your client's piece of land. And we are saying, as the Minister of Lands or as the minister so guided, the minister in her powers and as enshrined under the Constitution, Article, I think, 113, 111, 113, 117, with the mandate of policy oversight in land it fit that, yes, we have the law and we are not opposed to the law. That's the first thing. 2, but we have a problem. 3, whereas we are moving to amend the law, the amendment of the law is going to take some time, but we need to curb this problem as colleagues and as parties in the struggle. So it is against that background that the minister used her powers by virtue of the constitution and guided that, wait, let us first hold issuance of special certificates. Two, let us move to the stakeholders, and Uganda Law Society being one of our biggest stakeholders. We have actually received the letter, it is true, the letter from our president, our vice president, Anthony, giving their dissatisfaction, the members' dissatisfaction on the suspension of the issuance of special certificates. The beauty about it, he has proposed some interventions, like Mr. Kalikutima has stated. We have taken note of we've taken note of the guidance from Uganda Law Society, the advice from the Uganda Law Society. We've also taken guidance from Deo, as he has stated, and we are open and willing to take more guidance from the members. Why? On how to curb this problem. This problem, the fact is that it exists. We know that in the requirements under the law is that you make an application and put a statutory declaration, which is supposed to be on oath. And so the registrar will issue a notice to the Gazette, which will run for 60 days. And then thereafter, if there is no objection or otherwise, we are supposed to proceed and issue the notice. In our innovation as the Office of Titles, we saw that there was a problem, then we brought in new requirements, which requirements we know that are still not under the law, but in our wisdom, we thought that this will try to limit and try to ensure that Patience who is applying for the special certificate of title, one, she's actually the owner, and so in some instances, we've required the appearances of the particular applicants. Where Patience is a registered proprietor, we shall call Patience to confirm that indeed she's a registered proprietor. Two, we've always required registered proprietors to avail proof that indeed their special certificate of title is lost. How do they prove? We've always required police letters and police reports as confirmation. Three, we had also innovated and requested members that if you're applying for a special certificate of title, please bring us a letter of LC where the land is situated, confirming that indeed we know Patience and she has land in that particular area. All of these were intended to ensure that we try and curb the aspect of fraud. Risk knowing that those requirements are not in the law, but we are saying we think it was good practice to ensure that the patients registered on our register is the patients applying for the special certificate of title. Albeit those considerations and those new innovations, which we thought in our wisdom that could probably curb the issue of fraud in the special certificates of title, we still have fraud. How is it manifesting? We have had people where they are registered proprietors, they have given their titles to money lenders. And then the money lender has the title, and then the registered proprietor comes and applies for a special certificate of title. Trust me not that that applicant will provide all that, and we will leave out the fact that this title has been left with the money lender. And then days later or months later, you people, you issued, so we are held in a hard place and a rock, between a hard place and a rock. Two, we have had people who have left their titles, have made sales before us, the lawyers, and they have left their titles with you. And then tomorrow, the person who sold today comes up and applies for a special certificate of title. So Deo is busy keeping the title in his law firm, and the applicant is busy applying for a special. Members, if we put this to a vote, that how many of us have read the Gazette last week, you'll find that even with the land friends, a quarter of us have not looked into the Gazette. And yet legally by law, it is what we are supposed to look through. The other instances, we've had people who have been declared dead, whereas they are alive. And then people have applied for special certificates of title. So these families, one person is keeping a title and another, and the other goes and says, no, we don't know where the title is. These are some of the instances that have kept occurring over time, and we think there is a problem. There is a problem. Actually, it is not thinking. We confirm that there is a problem. Which problem we as the ministry and we as Uganda Law Society should take by the horns, accept the problem and see how to tackle the problem. We are not opposed to the law. We know what the law is very, very, very well. We know what the law is and we appreciate the law. We have had our colleagues, we as lawyers, lose land. We have had judicial officers, we've had politicians, and it is a special certificate of title. When you read through the file, everything is on file. The question is, where is the problem? We can only find the problem and the solutions with us as the stakeholders. It is on that note that we actually going to move to, we request, I actually take the honor to request Uganda Law Society to what we have an interaction. The president's letter has made propositions, which we appreciate, but I think we're going to have a face-to-face interaction on the problem and how we think we can tackle the problem. Ladies and gentlemen, we appreciate the law as it is. We appreciate the economy that titles run. The economy is run on mortgages and financing, mortgage financing, and titles are a critical aspect in this. Mr. Kalikutima informed us, advised us to actually have calculated the positions. And we think we and you, the Ministry of Lands and the Uganda Law Society, we can have a concerted effort. Risk knowing that the law exists. There's a problem which we have to handle. Which problem shall be handled when we acknowledge the problem? Our clients very, very much request or I need of these titles. Very, very much for one transaction or another. However, because of the problem, we are also held between a hard place and a rock, and we need solutions on how to solve the problem. It will be so unfortunate for us to proceed with the issues of titles without solving or without getting guidance or recommendations on how to solve the problem. And then a year later, we come back and still blame the Ministry of Lands. The courts have fined us heavily in some of these transactions. Heavily in some of these transactions. So we think with your concerted effort, with your Uganda Law Society and the members, we think as one of the biggest stakeholders, you can guide us better, and we are open to guidance. Other than that, I want to thank the management, the leadership of Uganda Law Society and its members for the opportunity of giving us a platform to try and explain. I know it may not be convincing to many of us, but it will not be convincing if you have not yet been a culprit. If you have been a culprit, you know what we are talking about. Mr. Kalikumtima knows this very well. Otherwise, I bring greetings from the Minister, the PS, and the Commissioner Land Registration. They send greetings to Uganda Law Society. Thank you very much, Patience. For now, let me end it at that. Thank you.
Thank you so much, Mr. Sechito, and kindly also do extend our thanks to the ministry I think it's very important. Usually we reach out to, when we're having these discussions, we reach out to institutions sometimes and they are unable to respond, or they don't even send a representative. Yet that also makes it difficult for us to have a balanced discussion. It doesn't make sense to come here and, talk about what the minister directed, how it's unlawful, yet you're not giving the minister a platform to also share their side of a story and why they came to that point. So we really do thank the ministry for delegating you to be here and at least iron out some things and make some things clear to us. We're very grateful for that, sir. Still on this topic, we are also honored and delighted to be joined by SEMA Properties Limited. We had initially invited the managing director, Haj Semakula Sulait. However, unfortunately, he got a busy schedule and was unable to be with us, but he has delegated the human resource manager, Mr. Tadeo, who is here on the call. As you may well know, SEMA Properties is a real estate company, and for most of these companies, they are really more like intermediaries. They give the service between people. We help them sell and manage properties. So these issues of titles are also very key to them. I'm sure there's so many clients who may be very disturbed or aggrieved by this directive that came out. And if issues really do touch the public, we try to reach out to all stakeholders that we can have so that we can see what is the best way we can work together to resolve, to have a practical solution moving forward. So we are honored to have Mr. Tadeo on the call with us today. Mr. Tadeo, you're most welcome. We are glad to hear from you. Mr. Tadeo, if you can hear me,
yes.
You can unmute.
Good morning. Good morning, Patience. Good morning, colleagues all online. Manyile Tadeo is my name, the Human Resource Manager, SEMA Properties. We are glad to be invited on this discussion. Suspending the issuance of special certificate or titles, at some point it will cause a lot of challenges, most especially to us land dealers. In most cases, there are some questions we must ask ourselves. Why do people apply for special titles? Then secondly, the process that is taken during the gazette thingy and the rest. To me, suspending won't work, but we can rather get some other means how we can the ways to go through while applying for a special title. True, it is not only in titles where we find some, should I call them what? This side we call them the bufferes. They are everywhere, but we must make some means of how to stop them. Because you cannot say that you will not issue a special title to a person who is owning his land just because he either lost the title or the title got spoiled. Because most of the people, they don't know how to keep these titles. Because it is a title is something special. Some people do take them to banks just because they can't keep them themselves. They are not safe. So for us, what we can say is that let us look into the process of acquiring a special title. We do due diligence, most especially the ministry, before the ministry issues or accepts the application. Let them do the due diligence before they issue, because sometimes you find someone applying for a special title, like my colleague talked about it from the ministry, that some do put those titles into money lenders, and failing to get it from there, he decides to apply for a special one. So let us look into the process. We tighten if it is to be tightened, but we don't suspend, or you don't suspend. That is all I can say under that process. Otherwise, I thank you very much to Uganda Law Society for giving us this platform. That is one. Secondly, even fine, it is being brought up, but let us put in consideration that there are some people who are genuine and applying for special titles, that they are genuine on their lands. But if we say that we suspend the whole process, then it will not be good for Ugandans. Thank you very much.
Thank you so much, sir. Thank you so much, Mr. Tadeo. Participants, colleagues, those on the call, kindly do feel free to share your questions in the chat so that the panelists can be able to address them. I think we shall. I'm seeing a few questions that I've received on the other online platforms that I'll be reading out. They are mostly to you, Mr. Tadeo. Councillor Kalukumutima noted that he has another engagement, so he had to drop off earlier on. So maybe for him, I may not read out his questions, but I will focus on the ones for the ministry. So I'll do the Q&A for each session because the sessions are a bit many today, to ensure that when we wind up one topic, we can quickly move on to the next. Okay. Mr. Tadeo, there are two questions, but there's one here that is from Mr. Vincent Kato, and as well as another which does not have, I think the person did not put a name. Yes, so let me just go straight to the one from Mr. Vincent Kato. He's saying, what would the 3 months, he says, thank you, Mr. Sechito, but what would the 3 months period change? If there is an issue of fraud, would the people still resume with their conman ways? So today, I hope that one is clear to you. He's asking what the 3 months period is, what will be the big difference within 3 months, what will be the changes seen. Then the other one is that the person has no name, so I'll just call them anonymous. He's asking how many officials have been investigated or prosecuted in connection with fraudulent titles, because we all know these are titles. We all know these are titles issued by officials in the ministry. How many have been investigated or persecuted in connection with fraudulent issuance? I hope those are clear to you, sir. The public, kindly, anyone on the call, please feel free to use the chat. If you're joining from YouTube or X platform, feel free to also use the comment sections. We can be able to see them on this side. Thank you.
Okay, thank you, Patience. Can I respond?
Yes, sir.
Okay, now in these 3 months, what we're going to do, one, we're going to investigate special certificates of title that have been issued in the period of at least the last 1 year. How many of them were problematic? How many of them were fraudulent? And how many of them were genuine? Two, did the right people apply for the special certificates of title? Three, what documents were used in obtaining these special certificates of title? And then we are going to interrogate what were these special certificates of title used for? Then three, we are going to do stakeholder engagement. Stakeholder engagement, we are going to talk to meet ULS, we're going to meet the judiciary, we are going to meet the police, we are going to meet the administrator general, we're going to talk to the AG, we're going to talk to, and the public.
The concern of, but the public gets to know. So in the public's eyes, it always looks like there's nothing being done. These people don't care about us, they just proceed as business as usual. So maybe as we also look around and think of solutions, there's also a need for accountability to the public to see that, there's a disciplinary procedure being done and that justice is being seen to be done, not just being done indoors. Mr. Sechito, I think lastly, there's just one more. This is from Nakaiza Julie. She says, if two titles are issued over the same land, how much of that problem is attributed?
It was easily possible to create a double titling. However, currently, because every parcel is linked to one title, I would say it's very hard to do a double titling. However, where it is done, in the unlikely event that it is done, we shall look at the cause of the double titling, but largely it is as a result of either an error or an error on the cadastre, where the registration does not speak to the cadastre. So in that instance, the blame, because I don't want to leave out the ministry, then I will be very defensive. The blame shall always be 50-50. And that is why we are saying that we are now linking all titles, the cadastre that is the survey and mappings, to the registration. So even when you go to these ministry zonal offices, colleagues, and they are telling you we have to link this spatial unit, there is that language that we lawyers don't know or don't want to learn. And they are telling you we need to link this spatial unit to registration. Please take heart, just try to understand and provide what is being given. I have devolved from the question Naka is asked, but I needed to inform the colleagues. But as to the apportionment, thank you.
Thank you so much, sir. I think on my side, those are the questions that I've received. Participants on Zoom, please feel free to continue sharing any comments or questions that you have. Mr. Sechito, Mr. Kalukumutima, Mr. Tadeo, we are very grateful. Thank you so much for making time to be on this call from your busy schedule. Mr. Sechito, as you mentioned that there will be stakeholder engagements, the Uganda Law Societies would be very willing to participate and offer guidance as per our mandate under Section 3D of the ULS Act. With our over 7,000 members, majority being land practitioners. So we have a vast knowledge and a vast team of experts who would really be, I'm very sure, very interested and very willing to offer support in this. So we look forward to any further engagements in regards to this subject. Allow me to close this first session so that we can move on to the next. Mr. Tadeo and Mr. Sechito, if you have time, you can feel free to stay on the call. We also have some very other interesting topics that maybe you'd want to hear about. Yes, but we really do appreciate your time. Thank you so much.
Thank you, Patience.
Okay, sir.
Thank you, Patience. Good day.
Have a good day, sir. Thank you so much. I'm going to make a bit of a switch to what was scheduled to be the third issue. We shall make it the second issue. Kindly allow me to do that. So we shall be diving right into the issue of bail. And we are very honored to have two young ladies, young lawyers, advocates who are going to be our key speakers on this topic. The topic is titled Beyond Cash Bail, is Uganda's bail system delivering justice? As you know, bail is an accused person can apply for bail before they are sentenced or before they are convicted, if not acquitted. So the Constitution recognizes the right to bail, also recognizes the right to personal liberty and the presumption of innocence But for many people, they spend a lot of time in custody while their cases are pending. And then usually when someone applies for bail, it's not really that automatic. There are some challenges that do come in, especially if there is like a non-cash bail imposed. So when court imposes such financial conditions, an accused person who may not be able to meet or be able to afford that money, it means that now securing their freedom or their liberty becomes a difficult question for them to address. So we want to have this discussion to understand, is our bail system achieving its purpose? Are we prioritizing the right to liberty, or would the right to liberty only be enjoyed by a certain category of Ugandans who are able to afford it? So are these bail conditions tailored to the circumstances of individual accused persons, or are they just, blanket bail conditions? Are we relying too heavily on cash and financial sureties when there could be, maybe there are other means that could adequately ensure that someone attends trial, because that's just what it's about, ensuring that you come to court and you don't abscond. So I think we've also seen in the past people who have not been able to raise the money. Maybe the most recent one was Mr. Malema Birizi. There was, I think, also on social media, there was more like a campaign because he was given non-cash bail of 5 million. There was a campaign and people were trying to, collect contributions to be able to secure this money. So today's discussion is very crucial. I encourage all of us that we can all somehow be entangled in this criminal justice system. Sometimes we think issues of crime don't concern us, but these things do concern us. Anyone is a candidate of being in prison or being a suspect in a case. Yeah, so today's discussion will allow us to examine whether Uganda needs to rethink its approach to bail, and whether we need to consider more proportionate, accessible, and rights-compliant alternatives to cash bail. As I mentioned, we have two young ladies whom we are honored to have on the call today, who will be taking us through this discussion. One is Miss Namitala Bridget. Bridget will be going first. She's a human rights lawyer, driven by commitment to human rights, dignity, the empowerment of women and girls. She's also passionate about gender-based violence prevention and response, survivor-centered case management, safeguarding policy development, and gender mainstreaming within the community. She's the founder and program lead of the Risen Girls Initiative, which is a registered grassroots community-based organization. She has directly contributed to transforming the lives of over 500 young women across Uganda through community legal aid and workshops on reproductive health rights, leadership, gender-responsive environments, and school retention rights. She's a proud alumna of the FIDA Uganda Leadership Academy, US Department of State Exchange Program, the Harvard Aspire Leaders Program, and the Forum for Women in Democracy Transformative Leadership Program. Wow. Ms. Namitala, thank you so much for making the time to be here, and you're most welcome. Feel free to unmute and speak to the public.
Thank you so much, Patience, for the opportunity and for the great introduction. So like you've introduced me, my name is Bridget Namitala, and I'm a lawyer by profession and a very, very strong advocate for the rights of women and children. Yes, so because for the interest of time, I will directly dive into the discussion that we have today, and that is bail. What is bail, and how did we get to cash bail being one of the major preconditions for being granted that right? And does it limit someone's right to liberty if you enclose it into someone's financial muscle or someone's capability to actually fulfill this condition? And one of the questions that I think we should pose to ourselves before we even dive any further is, if justice is for all, does that promise survive when liberty has a financial condition to it? And then if bail is granted but the accused person cannot afford the conditions imposed, have we actually granted bail? And just like Precious has said when we were beginning this discussion, when Malema Birizi was granted bail, but then he could not afford the cash that was attached to that bail, then I don't think that right has been granted, because there has been a financial condition that has been attached to someone actually achieving that right. So these questions I've posed and are things that we should think about, because they go into the heart of Uganda's constitution, commitment to personal liberty, equality of the law, and the presumption of innocence. Have we actually presumed someone is innocent if they have fulfilled all the conditions for bail, but because they cannot pay a certain sum of money, then we cannot let them go, meaning we have not actually even given them a presumption of innocence, personal liberty, not even mentioning our prisons that are actually very congested. And I believe these are rights that we should look into very, very importantly. Let me just switch off my video for a second. Yeah, so I will dive into the framework quickly, really. So Uganda's bail framework is in many aspects about personal liberty, the presumption of innocence, and the equality before the law, as already enshrined in Uganda's constitution under Chapter 4. And the deeper problem here is actually not cash bail. The problem is the possibility of converting the judicial discretion into conditions that are inconsistent or practically inaccessible to a certain class of Ugandans. And this is, we're not saying that we should abolish cash bail, because we have precedent that has actually said, you know what, cash bail is important. And in some cases, yes, it is important. But the question should be, when you are giving out cash bail, liberty should be a starting point. That detention should be justifiable, and this person must really must demonstrate a risk to the society or to the case. Bail conditions should be reasonable, and they should be reasonable in a literal sense, and cash should not automatically be a preferred option if there are other less restrictive alternatives that are available to a person. And then mandatory bail is effectively monitored and enforceable. Then victims and witnesses are adequately protected. And most importantly, poverty does not become a hidden sentence before conviction. Because honestly speaking, how many Ugandans even earn $1 a day? Most of Ugandans are below the poverty line. And then really, when you bring this as a condition, and most of the times we do not even have any proper legislation or proper procedure of which cash bail is determined. It's always at the discretion of the judge. And sometimes, or most of the times, it's actually at the detriment of the person that has actually been granted bail. So these are questions, those are things that at least we should consider. If cash bail, we must go with it. So diving into the major heart of this conversation is beyond cash bail. Do we have justice in Uganda's judicial system or bail system? So I will also ask a question to myself to be able to answer the other questions. And can Uganda create a bail system that is, first of all, lawful, reasonable, proportionate, consistent, evidence-based, and genuinely accessible for both the rich and the poor? Because if some of us here that are lawyers that have had a chance to read the different bail cases, we have here the one of Dr. Kiza Besigye, Kuku Moses versus the Attorney General, and so many others. I might not be able to finish all of them. We've realized the pattern. There is no bail case that gives clear precedent that this is how we actually handle bail. It's mostly about who is applying for bail. We have guidelines that govern the bail system, but when you read precedent, it's always different. Who is that party? Who is asking for bail? And then we shall see how to handle this very matter. And then I really think that is not something that is reasonable or equal. We do not accord equal rights and opportunities to people if this is the system that we intend to take. This is something that we need to think about, and I think the judiciary should also look into it, that as we are making all these things, have we looked at the kind of precedents that we are leaving behind? Most of the times I tell so many young people that I talk to and my fellow peers that when we read these cases, or when we see the things that are going on in society, these are things that are going to be marked in history, that at such and such a time, so and so did this. Because we are building our foundations on the same things that we found that our predecessors left. So the question is, what have you done to leave the world a better place for the people who are going to read about you, or for the people who are going to say, in your generation, what did you do? What is history going to remember you for? Are we going to remember history where someone was granted bail and 3 minutes later they were picked up? Are we going to remember history where someone else was given an unconditional bail, or was just let go, and then someone had everything? They had a place overboard, they had everything that the law provides them to have, and you just did not grant them bail for merely stealing? Crime is something that we live with, but how do we handle? I don't want to say merely stealing and then I just seem like I'm not condoning crime. Yes. So that's something that we should really look into as young people, and as people that are looking forward to leaving the world a better place for the people that are coming forward tomorrow. So as we understand bail, as I earlier mentioned, first of all, when we are handling bail, was the accused granted bail? Okay, and did we grant him bail or did we give him an opportunity to be given bail? Did we give him a realistic opportunity to remain free? That's something that I'm trying to bring out. Or did we just grant them bail by the book, and then we actually did not grant them a realistic opportunity? And this goes back to the heart of the discussion that we have today. If the law does not make mechanisms for formal justice and substantive justice for all people, then really we cannot start even having discussions of bail. Okay, because bail is a right at the discretion of court, but really it's a right you give to someone who you still presume innocent, and that right also comes with personal liberty. But you cannot grant that right if you put conditions that cannot be brought to fruitfulness. So if cash bail remains part of the Ugandan bail system, it can still be used if bail conditions should be risk-based, not wealth-based. How much money can this accused person actually produce? You know, have you looked at how much someone earns, the kind of assets they have, their financial muscle, and their sureties, and how much they can actually put forward? Then what condition is reasonably necessary to ensure the accused person's attendance to protect the integrity of the proceedings? Because really you can look at a person, their flight risk, they're always up and down, and then you can really weigh and see that this person, the way we've assessed these conditions, they are a risk. But if they are not a risk, someone doesn't even hold a passport, they have never flown out of the country or in East Africa, then how are you really looking at this threshold of the cash bail? Then number two, cash should not automatically be a default condition. Okay, when non-cash conditions are adequately addressed, the identified risk, court should be prepared to consider that the person has sureties, reporting requirements, residence requirements, surrender of travel documents, restrictions on contract with particular persons, and that all lawful conditions were fulfilled. And the objective here is to basically create less restrictive conditions capable of achieving the legitimate purpose of bail. Okay, we agree bail is at the discretion of court, but it's also a right that is given to us by our constitution. So when granting bail, are you giving less restrictive conditions that a person can actually achieve, and you're also giving bail a legitimate purpose, not merely a charade or just a cloud that there is actually bail, yet it's not there. Number three, the amount of cash should be objectively reasonable. And this is something that I discussed earlier. Where a cash bail is imposed, really the amount of money should not be arbitrary or or excessive for the person to achieve after looking into that person's circumstances. A condition that is so high becomes really impossible to satisfy or operate in this or operate really in those particular instances. And then the fourth and the last, so court should give reasonable reasons or for the conditions given, you know. So if court has given a particular threshold of cash or particular conditions that a person should fulfill before being given bail, court should at least be able to address what risk is court addressing for these conditions. Why is this condition necessary for granting this person bail, and why this amounts to a reasonable condition? Why would a less restrictive alternative not adequately address the risk? I'm not trying to sound political, but the best example that really I know bled most of the hearts of Ugandans was recently, in the middle of the year, we had a prisoner who lost a wife and they're in prison. Really, every condition I really believe as a Ugandan citizen could have been met for the sake of humanity, personal liberty, and the kind of precedent that we are leaving for the generation tomorrow, and for those young children whose that memory will never leave them. And this is a person that has not even been tried fully. Really, the case, we are still presuming them innocent, but then you could not grant them bail. You know, this is a person that we believe to be a reasonable member of society and so many other things, probably, and you cannot grant this person a conditional bail for a particular period of time. So, and these are not things that court tells us, you know, why are they refusing? What risk is court addressing? Why is it necessary? You know, and all those other things. So really, I think this is something that we should all look into. And the other one, the court should consider practical affordability. Yes, so practical affordability is what is the heart of this cash bail, beyond cash bail. You are giving someone a cash bail of 10 million and someone earns 500,000 a month. Really, how are you expecting them to pay that kind of money? And then it takes us back, what is the importance of the sureties if it's at the end of the day it does not count, or it's not something that is going to yield to a proper justice? And also, as something that we need to look into as Ugandans, as much as we say that our prisons are populated, the population is so high. When the Uganda prison releases reports, even as per the report of June 2026, the prisons are so congested. But all the people, the majority of the people there are even on remand. And the question is, why aren't those people being granted bail? Have you given them that right? What kind of offenses did they commit? So I believe also such conditions that frustrate bail, in the other hand, bring a financial implication and a financial burden to the budget of this country, because they are fed, prison guards are paid, and at the end of the day, it actually even affects our treasury in one way or another. And lastly, as I conclude, we have regions in East Africa. We have countries like Kenya, which have adopted some laws to try to guard the bail systems in their own country. And I believe it's okay for Uganda to pick a leaf from our neighbors, from other jurisdictions, for a better country. I will specifically highlight Article 49, Clause 1 of the Kenyan Constitution, which provides for release on bond or bail on reasonable conditions, unless there are compelling reasons for continued detention. Okay, and it also emphasizes reasonable conditions, the risk of absconding, protection of victims and witnesses, proportionality, and alternativeness to. So I believe if as a country we can adopt such things, we could have a reasonable discussion on cash bail and beyond, and bail as as a whole, because it is an area that we need to develop a lot. And I believe it's a precondition for the development of our criminal justice system. Thank you very much for the opportunity. I will conclude on that. Thank you very much.
Thank you so much. Thank you so much. I believe you've made a very able and good foundation for this discussion, starting off with defining what bail is and helping us to get it from the get-go, what it means to be able to afford cash bail in some instances. Thank you so much. We shall also be hearing from a second speaker. Let me just remind all participants kindly, any questions, any reactions that you have, comments, please feel free to put them in the chat so that we can be able to put them forward to our panelists before, as they're winding up their discussion. Our second speaker on this topic is a law graduate of Uganda Christian University and a recent graduate of the Law Development Center. She currently works with Ananda Center for Cancer Research, where she supports legal research and policy development, including contributions to national discussions on HPV vaccination and cancer policy. She is interested in access to justice, legal reform, and the role of the law in advancing equitable public policy. This is Miss Hilary Agnes Ataro. Ms. Ataro, you're very most welcome, and we are happy to have you.
Thank you very much, Patience, and thank you, Bridget, to the members of the Ugandan Law Society, my land colleagues, all distinguished guests and all in attendance. A very good morning to you all. My name is Hilary Agnes Ataro, and I want to thank you all for the opportunity to contribute to this discussion. So in the interest of time, I think I'll just begin with what I consider one of the most important questions that really brings us to this discussion. Is bail a matter of money, or is it just a matter of liberty? Because for many Ugandans, the answer seems just obvious. Bail is money. So when you speak of bail, to them, it's money. And if you can pay, you go home. If you cannot, you remain in custody. But, you know, with respect to the law, it tells a very different story. You know, bail is not all about money. It's about acknowledging a fundamental principle of our criminal justice system. You know, that an accused person is presumed innocent and should remain at liberty as long as they can be trusted to return to court for trial. What this really means is that when someone is arrested and charged with an offense, the law does not immediately have to treat them as guilty, because at this stage, nothing has been proven against them. The court has not yet tested any evidence, and so no conviction has been made. So the starting point of our criminal justice system is actually very clear. Liberty is the default position and not detention. And this is why bail exists. But, you know, bail is not simply release without structure, like Bridget has mentioned. It is not an automatic freedom. It is a legal mechanism, and that tries to balance two things. First of all, the individual's constitutional right to liberty, and also their need to ensure that the administration of justice is not frustrated. So this is all embedded in our constitution. If we look at Article 23, Clause 6, when we read it together with Article 28, Clause 3, it embeds the presumption of innocence. And our courts have repeatedly emphasized that this presumption is not symbolic. If we go ahead to look at the case of Orago Moses versus Uganda. So when court considers bail, it is not asking, is this person guilty? It is asking, can this person be trusted to return to court when required while we wait for trial? And that is really the big question behind bail. And so that is why courts are given discretion to impose conditions such as sureties, reporting obligations, or in some cases, financial guarantees. And these conditions are not meant to punish the accused. They're just meant to secure attendance and to protect the integrity of the whole trial process. And when we look at the precedents of Uganda versus Kizza Besigye, court just made it clear that bail should never be used as a form of punishment, because that would contradict the presumption of innocence. So in simple terms, bail is not about declaring innocence or guilt. It is about managing risk while respecting liberty. And it really operates on the assumption that the accused remains innocent until proven otherwise. So that is the true philosophy behind bail. So when we talk about bail, we are really just talking about the balance of liberty and the administration of justice on one hand. And our courts have consistently emphasized that the main consideration in bail applications is whether the accused is likely to return for trial, so that we do not frustrate the whole administration of justice. In other words, at the bail stage, the court is not making a determination of guilt or innocence. It is just concerned with ensuring that the accused person will come back to court. So bail is not punishment. It is conditional liberty. So having established that whole principle, the next question now to all of us becomes, what happens where this conditional liberty is not immediately granted, or where an accused person remains in custody for an extended period of time? Now, this is where the law brings in an important safeguard, which is mandatory bail. So if an accused person has spent over 60 days on remand for a non-capital offense or 180 days for capital offenses, the law provides in our practice directions that such a person shall be released on bail. And we all know that this word shall it's not casual, it is deliberate. It reflects a constitutional intolerance for any prolonged pretrial detention. So in essence, the law is saying we cannot keep you in custody indefinitely when you have not been convicted. So an accused person cannot be punished directly or indirectly for the failure of the prosecution to do its job or to investigate in a timely manner. However, when we move from theory to practice, a very different picture now begins to emerge. Because while the law does not define bail in terms of money, in practice, we have come to see that bail is often a financial burden. If we just look at the recent case that is really bringing this issue into sharp focus, like Patience and Bridget had said, the Malay Maviridi versus Uganda, the court was confronted with a situation where the applicant had remained on remand beyond the constitutional prescribed period. And the court found that the 60-day threshold had been exceeded. So it held that at no discretion, it had no discretion but to grant this mandatory bail. So to that point, the Constitution is really speaking very clearly. The applicant must be released. However, this is where now the tension begins to emerge, that the court, despite granting mandatory bail, it is still imposing other conditions. The cash bail requirement, the sureties, the restriction on movement. And so what we are seeing in real time is that on one hand, the Constitution is insisting on release because continued detention is no longer justified. But on the other hand, the conditions that are attached to this release still determine whether that liberty is realized in practice. So even where bail is constitutionally guaranteed, its enjoyment may still be influenced by one's ability to meet these financial conditions. And still, this brings us to the central concern. If bail is mandatory, to what extent should this access to that liberty still depend on the ability of the accused to meet financial conditions? And for example, if you prescribe cash bail and I do not have the money, have you truly done justice to me? Also, what makes us really assume that the person who is able to pay cash bail is less likely to abscond than the person who cannot? Because if the purpose of bail is to secure attendance at trial, then the question should be about risk really and not financial ability. So if we reduce bail to a financial condition, we risk shifting the inquiry from will this person attend court to can this person afford their freedom? And this is really where the injustice begins to creep in, because in that situation, the person without financial means is effectively punished. And not because they are more likely to abscond, but simply because they are poor. Yet both individuals remain presumed innocent until proven guilty. So the question we must confront is, are we assessing the risk of absconding, or are we just unintentionally measuring economic capacity? And now to be clear, the law allows courts to impose conditions. Courts may require cash deposits, sureties, or any reporting obligations. In fact, Ugandan courts have repeatedly held that bail is about ensuring attendance at trial, and conditions are simply tools to achieve that. But the difficulty continues to arise with this one condition, money, because it seems to be becoming a decisive factor. And because at that point, we're no longer just regulating attendance, we are just measuring liberty by someone's economic ability. And so this is where the tension lies, because on paper, Uganda has progressive rights-based bail system, but in practice, its application can produce unequal outcomes. So two accused persons, both presumed innocent, are going to face completely different realities simply because one can afford bail and the other cannot. And so this concern is not really unique to Uganda, like Bridget mentioned. She cited in Kenya's law. And so cash bail is not the default. The focus is on risk management and not really financial capacity. And so that is the critical distinction. So as I conclude, when we step back and reflect on the questions we have raised, it becomes really clear that Uganda's bail system is in principle progressive and firmly grounded in constitutional rights. It acknowledges the principle of the presumption of innocence. It acknowledges that liberty should be the default. It attempts to protect individuals from prolonged pretrial detention, but the difficulty now arises in its application because we now see situations where the liberty is now depending on financial ability or one's financial muscle, as we could say. So that is when these difficult questions now begin to arise. Is it mandatory? Is bail mandatory? And why does liberty still come at a cost? If cash is prescribed and I cannot afford it, have you done justice to me? And if we're really assessing the risk of absconding or simply measuring economic capacity. So these are not just abstract concerns. They really go to the very heart of fairness in our criminal justice system. And perhaps that is where the real question lies. So that while our legal framework has moved beyond cash in theory, we must now ensure that its practice reflects the same commitment to equality and justice. So as we leave this discussion, I think this is something we all have to reflect on. And I thank you all so much for your attention. Thank you. Over to you, Patient.
Thank you so much, Agnes. Thank you so much for the discussion, and also for our participants that are still on the call. Thank you. We appreciate you being here. Bridget and Agnes, I've received 2 questions so far. I don't know, maybe each one of you can answer to them. I hope so. So there's one from someone called Solomon K. He says, they say that bail money is refunded, but I don't trust this government. How long does it take? And what is the process of getting back the money? I hope that's clear. Maybe you can a little bit take us through the procedure, the process, as well as the timelines of getting the bail money back. And then there's a second one from Beatrice Ojuka. She says, I think she's referring to the topic of discretionary cash bail. She says, should this be left to judicial officers, or do we need a law / an SI to that effect? I hope that's clear. She says, should this be left to judicial officers, ? Or do we need a law / an SI to that effect? I think Bridget and Agnes, maybe you can both, Bridget, since you went first, I think you can still go first and answer to those questions. Thank you.
Thank you very much. I will specifically answer the last question because it actually talks about some of the major things that I talked about in my discussion. When I mentioned that Uganda should borrow a leaf from our neighboring jurisdictions or some other common law jurisdiction, it's mostly a grounding law. We actually need a law that does not necessarily say you can apply for bail. We need a law that or just doesn't give conditions for bail. Like we have the bail guidelines, we have those, but we need a law that specifically breaks down cash bail. we need a law that says, that probably at least gives something for us to work with. Because like I mentioned, we have precedents, and so many of those precedents have been relied on when they are granting bail. But the question should be, are we going to look at the case when they granted Dr. Chiza Besigye bail and then he was later rearrested? Are we going to handle that bail case the same way we are going to handle the bail case of Kaku versus Attorney General? Are we going to handle that case the same way as we handle the bail applications of all these political prisoners that are in court? No, we are not, because they are not even being accorded the same procedure, the same rights, or even the same opportunities, even though even some of the offenses that they committed are not far away stretched from each other in a hierarchy. So basically, in Uganda, we still have a very, very long way to go to differentiate what a crime is from who committed it. We mostly look at personalities instead of the actual crime, and that's a very, very big danger to our society. So the only way, I believe, as a lawyer, as a human being, and someone that believes in equal opportunities and justice for everyone, I believe the best way to ground this is by law, because case law is failing us. I don't believe that's something that we can strongly rely on when we are having a very extensive conversation on bail, rights, and equality. If we can put it in our laws, and this is something that we talk about, unless being a discretion of a judge, where a judge can have their personal emotions involved in a case, or a phone call from a higher person. I believe if we ground it in the law, it actually also holds the judicial officer accountable for their decision that they are making, and we take it away from it merely being a discretion of court. And because just like Kenya did, they have a breakdown of something that are things that they should consider, leave alone what we have when considering when granting bail. No, at least Kenya has gone down to say bail guidelines and bail and bond policy guidelines, and they made a breakdown of the reason should be the reasonable conditions, the risk of absconding, protection of victims and witnesses, penalty, and alternativeness. And that's actually something that is very critical. Alternativeness to detention. Is there other alternative that we can take? Is there other alternative that we can consider other than cash bail? I believe if we have a law or something that holds both of us, the citizens, the judiciary, accountable, I believe that is a precondition that we need for a better light into our bail system as a general. Thank you very much. Over to you, Patience.
Thank you. Agnes, are you able to come in now?
Oh, yeah. Yes. Thank you, Patience. Sorry, I had been turned off. I think I'll answer Solomon's question, whether bail money is refundable. Yes, it is refundable. Cash bail is refundable when the case has been concluded. But this is provided the accused has complied with all the bail conditions. And so the process just involves a formal application to the court. You submit the original bail documents. Court will issue a refund order, and the processing through the judiciary. The law provides for 7 to 15 working days, but as practice reflects, this is really it takes quite some time. But yes, cash bail in Uganda is refundable, provided that the accused or has complied with all these conditions and has not absconded. If the accused absconds, the money may be forfeited to the state. So yeah, thank you. Over to you, Patience.
All right. Thank you so much, Agnes. Thank you for responding to the questions posed. Thank you also, Bridget. I think that winds up our topic 2. I'm not seeing any further questions. And yeah, I think that's wraps up our topic 2. Thank you so much, our panelists, for making time to be here with us. We really do appreciate breaking down these. Sometimes legal concepts can be a bit complex for the general public. So it is important that we have people who can ably speak to them and help us really do understand these issues deeply. And very big thanks to Bridget and Agnes for breaking that down for us. Really do appreciate. We're moving on now to the third topic. This is on tech, legal technology. And I think topic 3 does marry into topic, the last topic that we have, an update on tech first. But starting off with a topic of from views to value, the rise of content creators and a digital economy in Uganda. As we know, there has been a lot of change in the recent years. I think the last 10 years have been quite robust and a whole new world that we are in. We've been seeing Ugandans create, consume, and monetize information. Today, the smartphone in your hand, internet connection can turn you into a broadcaster, a journalist, an entrepreneur, a marketeer, media person. Really, you can be so many things just with a phone that you're holding. You can reach thousands. You can have your YouTube platform. You can have a podcast. Really, there are so many avenues through which people are able to reach the public and through which they're also able to make money. Most of these pages that we see are monetized, and it has actually now become like a real career of being a content creator, of being an influencer. So content creation has really moved from just being a form of entertainment. I think in the past, people would have their YouTube channels just for the sake of, something they enjoy doing. But right now it has increasingly become an area for earning money, and has become part of our digital economy, creating income and as well as employment. I think today we know that you cannot run a channel sometimes by yourself. You have to have a whole team of these guys that help you to like either set up or like even a manager or even like a camera person. It has created employment for many and also forms of entrepreneurship. But even if there has been this growth in the sector, we also have so many questions in terms of our regulation, taxation, intellectual property, issues of privacy. This has also been one of the key areas where we've seen litigation coming up, data protection kind of issues, online safety, and also maybe in regards to children and this content, being a bit too much for the kids or being immoral, stuff like that. Even questions of freedom of expression. I think we're all aware that there have been some laws that have been put in place and people have found them to be a bit restrictive, especially to freedom of expression, saying that maybe where we criminalizing hate speech, where we criminalizing what they are calling maybe malicious information. There's really been a lot of discussions, and this is all just emerging jurisprudence given the era that we are in of technology. So as we struggle to keep up, keep up the pace with these developments and keep up laws that will really ably address all these new things that are coming up, we need to keep asking ourselves whether we are creating an enabling environment for Uganda's digital creators, or do we have legal barriers that are holding the sector back, that maybe people are not able to earn as they should. We recently had a discussion on the Copyrights Amendment Acts, and then you have to ask yourself, are our laws also enabling the people who are in this sector to really do earn the way they ought to? Yeah, so really we are honored to have 2 key discussants today who will be taking us through this. I will be starting off with a second, please. I'll be starting off with Mr. Kayua Joshua. Mr. Kayua, I hope you're online. Mr. Kayua Joshua is the founder of Shatter Empire and Ghetto Talent Search. Mr. Kaiwa, we are so happy to have you. And as you know, this is it's by Uganda Law Society. However, it's open to the public. It's not limited to only lawyers. That people who are listening in also include really general people in the public who would like to understand content creation, earning from it, any barriers that you're facing really as a content creator. Your page is, guys, please go check out Shatter Empire on TikTok and Instagram and all other pages. Very, very entertaining and engaging content to see. Mr. Kayo, you're most welcome. We're happy to hear from you.
Well, I'm honored to be on this panel. Thank you, Patience, and everybody who is online. Well, content creation in Uganda right now it has become a big deal, and it has changed a lot of lives. So me speaking in a perspective of someone coming from the ghetto, I know maybe there are some people also who come from the ghetto, because I know a lot of lawyers who are ghetto youths as well. But I'll speak mostly about TikTok, because that's the platform that we're using a lot these days, and maybe YouTube. I'll first speak on the advantages of this application. Well, before TikTok came to light, there was no light in the ghetto. Like, people didn't know what's really happening down there, and most of the Ugandans thought that there's only criminality, thieves, whatever in the ghetto. But when we went to the ghetto, we took the camera to the ghetto, we are able to show the world what's happening in the ghetto, the talents that are in the ghetto, the fathers, the mothers, the sisters, the doctors, the nurses, the engineers, and everything. And it's really, really, it makes me happy to see that even the corporate world, they are now, trying to embrace these people from the ghetto. It was really hard for companies to invite, someone from down the slums, come and do this. They usually used to push them away because they feared, it's called stereotyping, how they looked like, and the rest. But now it's really changing. Yeah, thanks for TikTok and everything. But amidst the advantages of TikTok and everything, there's still some challenges that we are facing. First of all, that could be, I think, monetization. Because now here in Uganda, we are not being paid by TikTok. Even if you post a video and you hit a million views or million whatever, you're getting nothing. Another thing is, we are not. Let me talk about that. We are not being paid, and actually, some other countries, they are being paid for views, as you see on YouTube. Like, if you get these views, they pay you. But in Uganda, we are not monetized. This really, takes us back, because imagine if everyone was able to, to earn from their content. Uganda would be different. A lot of lives would have changed. The only way you can get money from TikTok, maybe when you do a live, someone will gift you. Then you can get money from there. Or maybe when you get business, because now we're having people who want to advertise their businesses on TikTok. They can say, oh, you have a good following, I can come do this and this, then you get paid. But to me, I feel like that's not really enough, and I don't want that. I would like at least people to be paid. Like I saw recently in Rwanda, I think they did something, they wrote to TikTok and also in Kenya as well, and they are pushing for their content to be monetized so that the people can be paid as long as they follow the right criteria. Like, maybe you have to be with these followers, like this and this. If you reach this milestone, then you'll be paid. I saw the Rwandese people pushing for that, and also I think like we have lawyers here. If we can push for that also here in Uganda, we can make good business out of it. Can change a lot of lives, because now TikTok is not just an application. We can even see the government institutions, they're really relying on this. people are no longer watching TV, even listening to radio. You just have a phone. You just have a TV in your hand. Like I've seen Honorable Balam, was moving around the country, arresting those people who do whatever, but he's doing it on TikTok. So if the government can rise up and write to these people, and they monetize our content, it really would be a plus for everyone. It would, like, even the unemployment rate will decrease rapidly. So those are some things that we want to change, like we would like to be changed, maybe if it's possible. And then the challenges we're having also in TikTok is the freedom of expression. Usually, recently I made a video because when we are down there in the ghetto, usually we have many people there. They are free. They can talk whatever they want. The numbers, where they are dressed, and whatever. But I think someone from X, that's Twitter, got this video that I posted, and then he posted it on X. Then he tagged Uganda police that these are the people that disturb us in the night. The following day, I was contacted by these guys, and they called me to go and report myself. But I did not do any crime. I just posted a video of Ghetto Youths, we doing our music stuff. But because there are many, maybe some are smoking, this really frustrated me, and I really felt bad because with what we are doing, we have like created a lot of artists here in Uganda. People who are thieves, who are criminals, and no longer stealing. They are focusing on careers. And if at all you find, someone can do that, and the police will invite you and detain you maybe for days, because of something doing to change the society or the people around you. It's really frustrating to us, and we don't know what the future holds, because now people, their eyes are always on the internet. So we are censored. You cannot do what you cannot express yourself because you fear that maybe there's someone who will see it in a negative way. Well, Patience, that would be my submission for now.
Mr. Kayo, have we lost you?
Hey, I mean, that's my submission for now. Maybe other people can discuss and we can, go on and on. But that was my submission.
All right. Thank you so much. Thank you so much. I think you have said something I didn't know about. I had no idea that TikTok content creators are not paid in Uganda. That is new. We have another speaker, Mr. Terry Kahuma. Mr. Terry Kahuma is an advocate. He'll be the one speaking second on this topic. He's an advocate and an award-winning Ugandan lawyer. He is the CEO of legal mobile app called Farmeron, which connects people and lawyers together, making access to justice easier. He is also the usual host of his legal YouTube and TikTok channel, which simplifies the law for the general public to understand, boasting of two segments. One, Legal News Daily, where he discusses current events happening all over the country and discussing it for the general public through a legal lens. Two, Legal Tips, where he gives daily tips on how to solve day-to-day challenges in life. Last year, 2025, he was awarded by the Uganda Law Society. He was given a Digital Excellence Award for his work on Simply Legal by Terry Kahuma. Ladies and gentlemen, it's our very own advocate who also does content creation. As you've heard, he runs 2 platforms, and yeah, we're so glad to have you, Mr. Terry, to tell us more about this and your views on our legal regulatory framework of content creation.
Um, good afternoon, everybody. Am I audible enough? Can everyone hear me?
What we can
Yes, we can.
Oh, you can hear me. Okay. Thank you for that, Agnes. My name is Council Terry Kahuma. I don't need so much introduction as my colleague has just introduced me, but I'll just give a brief introduction. My name is Council Terry Kahuma. I am an advocate of the High Court of Uganda and also subordinate courts thereunder. I am also the host of my YouTube and TikTok page, Simply Legal by Terry Kahuma, and also my legal mobile app Fameron, where I am the CEO. But mostly in today's topic, I'm here to discuss about content creation. Many of the times in Uganda, we always confuse influencers, content creators, TikTokers. But now at this particular juncture, I'm talking about the rise of content creators in our digital economy. In today's world, we're talking about AI. I mean, the word AI is being thrown everywhere. ChatGPT, artificial intelligence. But there cannot be a digital economy without content creation. And we see a big emergence of content creation having come up from maybe, let's say, 2016. And maybe by 2016, by then TikTok wasn't even a thing. We had mostly YouTube, we had Facebook. So content creators have been there, but the actual rise began from around 2015, 2016. Now, we had a big surge of content creation when TikTok came. That was during the COVID-19 lockdown, where we were all at home and we didn't have anything much to do. So we decided to go on TikTok and YouTube and start creating content. Now, when we look at the topic from views to value, anyone can be a content creator. Anyone can go and get their Techno or iPhone or Samsung, start recording maybe in a selfie kind of mode, or maybe a front camera kind of version, and then you start creating a video. But does that video you've created, does it have value? Or even if it has value, the information you're giving out in that video, does it have any impact in the community? And also, can that impact in community also convert into monetary value? So those are the questions that we need to ask ourselves in today's discussion. Now, when we say from views to value, we need to ask ourselves, if I am becoming a content creator, one of our case as lawyers, in this Rnblive, we need to ask ourselves, if I am aiming to be a content creator, what impact am I making in the community? What impact am I making in my country, in Uganda? Because our profession is all about bringing justice, access to justice, defending people in the courts of law, creating or drafting contracts. But we all know that that is where today's world is heading to, or that's where we are now. We're at a point where there's value addition in content creation. We are at a point where we are creating a lasting impression for other generations to be able to benefit from the work that we have done. So I'll give my case in point as an example. When I began my platform, Simply Legal, I wanted to find a way of how I can be able to cause or create an impact in today's society. That was about 2020, during when coronavirus had just started. So I wanted to find a way of how I can be able to create lasting impact in my society. Now we find that the value of the other TikTokers, the other YouTubers, the other content creators was in the entertainment world. People were dancing, doing dancing challenges. But I wanted to ask myself, the views that I'm seeing other people getting on social media, can there be value for the views that I'm going to add on TikTok or on YouTube or on Facebook or Instagram? So that's how I started to convert the legal knowledge that we have as lawyers to put it out there in terms of value. So that is where that's one angle where I can see from views to value. You can actually make the views that you are putting out there, or the content that you're putting out there, it can turn into educational value, or it can turn into information value. Because at the end of the day, what runs an economy what runs money, what runs the building of a country or a nation like Uganda is for people to have more information about what is happening in their country, what bills have been signed by the president, what bills are being tabled by parliament. So those are the things that I wanted the general public to learn about. That's how you can be able to convert views into value. And the mere fact that we're advocates, I believe every advocate is a genius. All lawyers in the world, in Uganda, in Africa, in East Africa, we're all geniuses. But just to be able to convert the legal knowledge we have and to convert our mindsets that lawyers are not only meant for court, we're not only meant to be desk lawyers, but we're also meant to convert the knowledge we have, convert it, and use these platforms such as TikTok and YouTube as conduits and avenues for which information can be able to be disseminated. So while I was one of the biggest mindsets I had was that a view is attention, a follower is an audience, but value is created when attention becomes trust. Trust becomes an opportunity, and opportunity becomes an economic asset. So I'll give you an example. I've done a couple of videos, I think about 3 or 4, in my content creation journey as a legal content creator. I have done videos about how to correct mistakes on vital documents like a national ID or passports or other documents. And we know that this is a very big challenge that people have faced in the past. They're continuing to face it, and they will continue to face it. So the value addition that such a video will do, even if it is 60 seconds, 10 seconds, or 30 seconds, if you're teaching someone on how to correct mistakes on their national ID, and you're telling them that a statutory declaration will help them, that can bring economic value to you, because you will be the go-to person that people go to while they are looking for a solution. While they are at the airport, they're seeing that their national ID is very different from their passport, and then they're stopping them at immigration at the airport. Or you find that they are passing through the border and they're not the same people as per their document or as per other documents. So lawyers, we are geniuses. We have so much legal knowledge. And all in all, why we are called advocates, in my view, is that we are helping the general public. We are problem solvers. Lawyers and doctors, we are the biggest problem solvers in the world because we touch people's lives on a day-to-day basis. Now, if a medical doctor goes, let me just give another case in point. If a medical doctor goes online and starts telling people on how to cure flu or cough, or let's say peptic ulcers, that doctor is going to get a lot of views. And those views, let's say that doctor in Uganda gets 10 million views. Even if TikTok does not pay that doctor, imagine how many clients he's going to get who are going to turn into patients for his hospital. So if he has a small clinic in Bokoto, or let's say in Charlie Wajala or Nalia, then he's going to get all, at least in those 10 million viewers who have viewed how to fix flu or how to fix ulcers, stomach ulcers. Then that guy or that doctor has added so much value on TikTok that he's going to be able to convert at least 10,000 of those 10 million viewers. It turns them into subscribers. The subscribers bring economic value, and that economic value will translate into bringing business to his hospital, even if that wasn't his intention. So I think the point I'm trying to make is value, the value addition. What value are your viewers getting when you put out information there? Now, we have to see that in a content creators world, as per what my previous viewer talked, as per what my predecessor talked about, Mr. Kaiwa, he is right. On TikTok, they do not pay content creators. However, when you look at a content creator's journey, you are more like a personal business. Number one, you have a personal brand. Number two, you have intellectual property. Number three, you become an influencer. You become a voice. You become a trendsetter, or you become someone who can move events. you can also get data about your audience, meaning that if you have 10 million views by doing a video on how to correct mistakes on your ID, then definitely you can see the metrics on your TikTok app or your YouTube app. How many of these 10 million viewers reached out to me? How many of these 10 million viewers left comments? How many of them liked? How many were converted into being subscribers? And you can even look at your personal metrics and say how many of them became potential clients to you. Because ultimately, as lawyers, even if we are advocates for the people, ultimately we need to survive because our profession needs to pay us. Also, you build big reputations because once your views become value, or once you add a lot of value through your views, then you build a very big reputation as a credible lawyer or as a credible professional, whether you're a doctor, whether you're an engineer. And also, lastly, potential revenue streams, because personally, I've been doing YouTube and TikTok for now coming to 7 years, and there are so many potential ways of earning from YouTube. First of all, there's something called ad revenue. So you find that the views you're getting by doing a video on how to correct mistakes on a national ID will not only bring you clientele, but they will also help YouTube to pay you by the kind of viewership that you're getting. If that video on a national ID gets maybe 20 million views, then those 20 million views are now converted into a monetary value. YouTube is going to ask for how long did people watch Terry's video, or for how long did someone watch Council Movie Rule's video on that, and also if they watched for a long time, how many liked and subscribed, how many shared this video. So all those are the metrics that these social media platforms and content creation avenues use to be able to gauge how much they can pay you. So also, we should not be discouraged that if TikTok doesn't pay, then I shouldn't start. You can start with other social media platforms where you know that you'll be paid with time. Yeah. So all in all, what I can say is, as I finalize, is that we should look at this simple formula: a view turns into an audience of people. That audience of people, with time, meaning weeks, months, and years of you putting out consistent legal content, it develops trust in your audience. So your audience develops trust in you. Then, while there's trust, you develop authority as someone who is an authoritative avenue for where someone can get information from. Then once you build authority, then you get opportunities. These opportunities can be brand sponsorships, brand deals. You can be taken to big universities where you'll be able to speak in other avenues. You can even be scouted out by the United Nations, other legal institutions across the globe. And most importantly, you become an asset because you generate a legal library or a professional library of your videos where someone can build trust that this person has been giving out information for the past 5 to 10 years. I think he has earned his credibility. So if a person watches your videos, that's a view. If they watch 10 of your videos, then you have an audience. Then they repeatedly hear you explain Ugandan law and other legal channels or other legal aspects that you bring up. Then you find that with time you become someone who is very credible, and that's how we can generate revenue outside the traditional court system, like drafting contracts, going to court. Everyone knows a lawyer for doing that. But if we go out and teach people these legal principles, break down the news for people in a legal or through a legal lens, trust me, the opportunities in content creation are endless, and I'd encourage every lawyer to do exactly that. So I think without further ado, I think that's really what I have to say. Thank you so much, everyone, for listening to me, and I'm open to any questions.
Thank you so much, Mr. Kahuma. Mr. Kahuma, we are so grateful. Mr. Kaiwa, there's some comments in the comment section. There's some hand claps and fire emojis. I think you're getting yourself new followers today. More lawyers will be following your page. Mr. Kahuma, there's just a question, I think, in regards to what you said at the end. This is my Consivira. It says, I'm a lawyer and I wanted to start a channel but I feel like the market is oversaturated with lawyers doing the same content. Do you think there's still opportunities for us? And then, okay, I think address this one first, and I'll read the second one after you've answered this one. Okay, let me just read it again. It's from Mike Consiviera. He says, I'm a lawyer and I wanted to start an online platform, but I feel like the market is saturated with lawyers doing the same content. Do you think there are still open opportunities for us?
Michael, you see, it's like asking, I want to become a lawyer. Let's say you're in senior 5 or senior 6, and you say you want to go back, you want to go to law school once you reach the university. Does that mean that you will not make money as a lawyer? Definitely you will. And there are so many lawyers. There are so many journalists. I'll give you a good example of a very good friend of mine who I have hosted on my channel. It's called Andrew Mwenda. I'm sure many of you know Andrew Mwenda. But Andrew Mwenda is a journalist who graduated, I think, in the late 90s, and he has had a very illustrious career in being a journalist. But you find that Andrew has surpassed so many expectations. He has surpassed even where he thought he would be. But there are so many journalists in Uganda or in East Africa or abroad. Why has he stood out? Because he looked for a certain angle under which he would tackle information. He would tackle the day-to-day needs of the people in terms of information. And you find that he has benefited a lot from his career being a journalist. So it's just about finding a unique angle where you can benefit or where you can exploit your career. So if you see that there's so many lawyers who are following suit of what Terry is doing or what other lawyers are doing online, then you will never start, because there are lawyers in the US doing the same thing. There are lawyers in the UK doing the same thing, giving out information. You just need to find a unique angle under which you can push yourself, or how you can be able to have your voice heard as an advocate. Yeah. So there's always space for you.
Thank you so much, Terry. We have another one. I think this one goes to both of you. The person didn't leave a name, so maybe we can just call them anonymous. He's asking, do we currently have any laws in the pipeline that can promote monetization of content? Or should we start from scratch on petition in Parliament to create a law, and how can we make this joint petition? I hope you've heard it. It says, do we currently have any laws in the pipeline that can promote monetization of content creation? Or should we start from scratch, petitioning Parliament to create a law, and how can we make this joint petition? I don't know, maybe Terry, you can go first, and maybe we can also hear from Mr. Kayo.
Okay, not that I'm aware of. I only know of laws where perhaps content creation has tried to be regulated. Perhaps when you look at the recent Computer Misuse Act that has been amended, when you look at other laws which have come up to regulate the digital space, especially in terms of content creators, it has looked at more of regulating what you say on social media, but not really per se monetization. So I think maybe we need to petition more in Parliament to see how perhaps we can incorporate it in the Tax Amendment Act.
Apologies, I think we lost Mr. Kahuma.
Oh, yes, it was regional.
Okay. Mr. Koma, kindly, if you can just repeat mostly towards the end. That's where we lost you.
Oh, okay. So basically, what I was saying was that I think we need to think of more ways of how we can incorporate ways on how the economy can facilitate content creators monetizing their brands, monetizing their information, and monetizing their content. I think it's something more that we need to look into. But if there are any laws that are in the pipeline, those ones I'm not aware of. The only ones that I am aware of are the laws which are meant to regulate what content creators say, instead of looking at more of avenues of how they can be monetized. But I think it's something we just need to keep pushing and maybe make some noise in the halls of parliament. We ask legislators to talk about such things. Yeah, that's what I can say.
Thank you so much, Mr. Kahuma. I think we've lost Mr. Kaiwa. He was earlier on, but I'm not seeing him anymore. So I think we lost him. I think this we shall be concluding this topic from here. But thank you so much, our panelists, for making time to be on this call. And I think, as Mr. Kauma said, lawyers on this platform, please don't shy away from coming out to start producing content that is relevant to helping the public. I think through doing this RNB weekly press and public engagement, we have learned that there's a very huge information gap. People who are able to access lawyers are not very many. Very many people have no idea of legal requirements, even basic things, as Mr. Kauma was saying, like the errors on national IDs, how to rectify these things. Even the topic that we had earlier in the morning about suspension of special certificates of title. You find that many Ugandans are not aware about all these new developments that are happening, even legal procedures, company registration, basic day-to-day things. You find that people find themselves caught up in even breaking the law because they are really not aware. I think currently our population is over 50 million. People may say that the lawyers are many, but really the ratio of lawyers to the population is still low. So the public needs us, the public really needs us. And with the way many Ugandans are using TikTok, are using Facebook and YouTube, it's a very good platform for you to be able to reach them and, also extend this legal advice and knowledge to them, and also grow your clientele. Who knows who you find in watching one of your videos, or what opportunities can open for you. So lawyers, let us step out and market ourselves better, and also help the public get this information, because it's also their right. Okay, thank you so much to Mr. Kahuma and Mr. Kaiwa. We really appreciate your presence here. The Rnblive has been a long one, so many topics, but we are finally getting on to the last one. The last one is our second digital transformation festival, that is the Tech Fest. For our ardent followers, we launched the Tech Fest last week during the Rnblive, and we talked about how we had the inaugural Tech Fest last year, 2025, at Speak Resort Punyonyo. And we are very blessed and honored to be able to have a second one this year, to be one of a kind. We call upon all the lawyers to join us, and this time it's different, it's regional. I think as we've been following, was receiving on our emails and the various ULS platforms, we are going to be having it in Western Uganda, Northern Uganda, Eastern, and then the final big festival here in Kampala. So that will be Mbarara on the 14th of September, Gulu on the 15th of September, Mbale on the 16th of September, and in Kampala it will be running for 2 days. That is the 17th and 18th. And you will be getting yourself 10 CLE points. As of last week, our chairperson announced the early bird tickets. So I think that timeline might have expired, but we shall be hearing from him to let us know more. Yes, so we shall be getting an update from the one and only Tony Kire Galandi, who is the chairperson of the TechFest committee as well as the convener. Mr. Galandi, it's a huge honor to always have you come in and speak to us. We are looking forward to hearing about the updates on the upcoming TechFest 2026. You're welcome, sir.
Thank you very much, Pesh. It's always a pleasure to be here. First of all, I'm really very, very excited about this second annual Low-Tech Festival. We are building on what we had last year, and we're making this one bigger and better. And this time round, we are creating a more practical environment. And what is different this year? Number one, we are running a hackathon. So if you have that young brother of yours who is very good about innovations, and if yourself you are a tech innovator, you have a solution that you have been struggling with, you are seated with it there, maybe it is able to solve case management, maybe it is able to do file distribution, maybe it is able to do cash analysis for the lawyers, maybe accounting for the lawyers. We are giving you an opportunity to be able to compete. And we have gotten a funder on board who is going to be supporting your idea to roll out. We'll be announcing that funder next Thursday. The applications for hackathon are out. You can simply send an email to member affairs. You can simply write memberaffairs@uls.org.ug. I would not mind if you can copy me in. I can always also follow up. Simply Kire, as in a KIRE-GT, G for good, T for time, at diamondadvocates.com. Small letters all through. We have a hackathon running, but that is not the only game changer. The other game changer this time round is that we have international developers of most of these platforms you keep using who are going to be joining us to exhibit. But the other thing is that we are having what we call as regional mini tech fests. So what does that mean is that if you are in Arua, you are in Moyo, and you are not able to come to Kampala, and you have paid your full amount for senior members, 500,000, for junior lawyers, 350,000, you paid your money, but you don't want to travel to Kampala. You won't miss out because we have created, we're going to have a mini tech fest in Gulu on the 14th of September, 2026 at Gulu University. And we are working in collaboration with Gulu University and the Innovation Hub there. So you are going to have the practical feel of these things. And the same is going to be in Mbarara. That is going to be on the 15th of September. And it's going to be at the LDC Center. We'll have another mini tech fest there. And then we'll have something in Gulu at LDC, sorry, in Mbale at LDC. So that is just part, it's an ice, it's just a tip of what you expect. You are going to interact, you are going to learn prompting. Many of you are using Grok, ChatGPT, Cloudy to do your research. The question is, do you know how to use these tools actually to get for you a right document? Don't miss this tech fest, please. Be there and you come and interact. By the way, The Tech Fest we have arranged this time, we are arranging it more of a cocktail kind of environment, away from the traditional lecture, so that you can be able to be on the same cocktail table with that judge you'd want to seek advice from, with that state attorney, with that DPP, so there's going to be free interaction. We are arranging it a whole in a manner that we this traditional thing of having the haves and the have-nots, the big dogs and the small ones, that's not going to happen this time. We are creating a collaborative environment that you can easily move around and have a chat with a person A. So this time it's going to be bigger, it's going to be better. But next Thursday, we will be launching another huge gift. Last year we had a Mercedes-Benz. I can tell you, we are having something bigger again, which we are launching this Thursday. Last Thursday we launched the land title. I can tell you, next Thursday we are launching something bigger. And I can tell you also that we are also going to have people who received these gifts. When I told people that we are going to give out a Benz, many of you never believed us. And until somebody got the keys. And surprisingly, the gentleman who got I was very impressed. The person who won the Benz was a young lawyer, so he's also going to be around to encourage you to join us and let us come and breathe. Yeah. It's no longer going to be a lot of tightening. We are going to be very, very relaxed. We want a relaxed Tech Fest. Yeah. Where you go away from your clock and tight jackets. This time around, we want to make it lively. We want to make it casual. Yeah. And we feel the Tech Fest. So, ladies and gentlemen, I also want to encourage you. Number one, the discussions, the whole of this week, next week, and the third week, we are going to be hosting different innovators on different platforms to talk about their innovations so that you know what you expect. Follow this season here. And we are using the following platforms. Number one, Leg Tech Dialogues. On X, it is L Tech Dialogues. And we also host those discussions on my personal X handle, which is at Tonekire. Follow those pages at Tonekire. And we will host these discussions. But also we have some other spaces which we are collaborating with, spaces like Lexora, spaces like Low Point. We are going to have these discussions there, and we are going to be hosting one person at a time, and we are going to spread them across all these sites so that you get the feel of what's coming. Yeah. I can tell you there are lots of innovations young men and women have come up with, and we look forward to having you. Mark your calendar. Next Thursday, we are going to be unveiling something very, very exciting. You don't want to miss out. I want to thank you, everybody, and I encourage you to pay any time, reserve your position, reserve your seat, so that we can be able to organize something that's very impactful. Thank you very much, Patience. I would not really want to enter into people's lunchtime. I want to just encourage people to pay. I want to encourage people to, those who want to exhibit, to register with the Uganda Law Society. The numbers are on those websites. The emails are on the ULS websites. Get in touch with Doreen, get in touch with Maggie. Their emails and numbers are on our different flyers. Share this information, move the flyers so that we can be able to have a very, very active and interesting conversation. Thank you very much, Pesh. And I think I have nothing useful to add after those very humble submissions. Thank you.
Wow. Thank you so much, Mr. Galandi. You see, you showed us the land title last week and we thought it was a joke. Now you're unveiling something else. I'm sure we all can't wait to see what that will be. Last year's Tech Fest was massive because of the goodies that were won. Of course, the Benz was the highlight, and there were many more that were won. So, guys, please let us ensure that we are all part of the Tech Fest. Even those who cannot make it physically, please make sure that at least you attend online. And as Mr. Galandi has said, all the information is constantly being shared on the membership emails as well as on all our platforms. Even the numbers to contact in case you need to make inquiries about how to pay and really several other things, even how to sponsor, how to partner. Please feel free to reach out to the Uganda Law Society. If you want to come here physically, we can also receive you. We have a department for our members' affairs that has all the information on how to support you to be part of TechFest 2026. Thank you so much, our chairman and our convener, Mr. Galandi. It's always a pleasure, always an honor to have you. And as he noted, we shall be having the TechFest updates every Thursday. So whenever you tune in for Rnblive, please be ready to listen from the TechFest committee. It could be Mr. Galandi or any other committee member, or even the personnel from the members affairs department. So we're looking forward to having all of you, those who are in the regions. We've not left you out. The information is clear, Mbara, Mbale, and Gulu. Make your way there and you will enjoy yourself and have a great time, and as well as earn your CLE points. This comes to the end of our Rnblive weekly press and public engagement. Thank you so much. Special thanks to the panelists, to the key speakers, those that we wrote to and they were able to confirm their participation. We are so grateful. Also, all those who have been joining us on our various platforms, YouTube, Zoom, X, it's always an honor to have you every Thursday. We look forward to having you next Thursday, same time, 10 a.m. and the same platforms it will be running live. For myself and the team at the Uganda Law Society, we say have a good afternoon. God bless you and see you next Thursday.